less than 1 minute. There were 19 special appeals before the Honorable High Court Mullet's division bench. The SLP is only in one matter. In the other 18 special appeals, there is no special petition before your lordship. It is well settled. I have 5 judgments that if inter se parties there is no appeal filed, it attains finality. That is res judicata. They had to challenge in all the 19 matters. I am appearing for those who is not a party before your lordship. I have filed my intervention into implement here, saying only this: in my matter there is no challenge before your lordship. Therefore, the status quo should not operate quaintly. As that's a simple point. Not getting into other merits, there is no challenge in 18 writ appeals. There is a challenge only in one matter. And your lordships have said in a collateral proceeding, in a separate proceeding, in one appeal out of 18, you can't set aside the judgment, quay all the 19. They have to be parties. If I were not to come here, that judgment, if your lordship were to reverse it, will operate only quay the respondents, not against NIM.
In those remaining 18,
yes.
How many persons were party?
I am told in this one, I've seen that there is not a single private respondent who's a party. It's only the state and other official respondents. Not a single private person, contesting person, private person is a party in that. There are 461 petitioners, but there is not a single private person. On this short ground alone, our appointment should be through. Not getting into other facts that they participated in the process, etc., all of that. And I have authority directly on this. On simple preliminary point.
Yeah. Lord, I am appearing in 114.1. I was supposed to be the last batsman, but I am put in the forefront. But Lord, whatever. I'm ready.
Sometime you know night.
Yes.
Night watchman did miracle, no?
Yes. No, Lord, I just. Yes.
Because of the captain of the team having a trust on you.
Now, Lord, kindly take this paper book for a minute and let me just tell Lord what the broad outline of the matter is.
The broad outline is fine.
Yes.
But what he is saying is...
Perhaps, Lord, that can also be resolved. Lord, may I just take... Then, Lord, Lordship.
All right.
But what has happened is that there have been advertisement in December 2016 for recruitment of about 12,460 teachers. There were 2 main conditions. One is that the candidate who applies, he must have done his basic teacher training course from that district only, and in only that district. So this was not subject matter of change.
BTC from anywhere?
From that BTC from the district he has he's applied. That was the condition.
BTC must be from the same district.
Same district as per the
rules
to
which he is applying.
Yes. Now, Lordship may just have a look at the exact words at page 45, because that's a very, I'm not troubling your Lordship with everything. It says that the vacancies in the list
14.1.
Yes, 14.1, inviting applications.
Page number?
Lord, page 45.
Page 45.
Lord, that rule is reproduced, one sentence is good enough.
Yes.
It says determination of vacancies and preparation of list in respect of appointment by direct recruitment to the post of mistress of nursery schools, assistant masters, etc. The appointing authority shall determine the number of vacancies as also the number of vacancies to be reserved for candidates, etc., and notify the vacancies in at least 2 leading newspapers having adequate circulation, as well as in the concerned district, inviting application from candidates possessing prescribed training qualification from the district concerned and who have passed teachers eligibility tests conducted by Government of Uttar Pradesh. So, Lord, the applications were confined to the candidates who have obtained the prescribed qualification from the district concerned. this was not the subject matter of chailing, which Lord the High Court, just to
Yeah,
Lord,
how it is from district, from where it is?
Lord, this says
It is of determination.
application from candidates possessing prescribed qualification from the district concerned. Qualification from the district concerned.
This
So-
cannot be interpreted like this.
But not-
Qualifications from the district concerned.
Yes, Lord, this is how it was.
This would only be read to the extent
Yes,
that a person should have applied for a district, unlike having a qualification, nothing more.
but that can be one way of.
As one way of presentation as per you, Mr. Zul.
Yes.
We are not denying of this.
Yes, Lord, the
But we
matter.
are saying this is the intent is just
Yes.
read in a different perspective.
Correct, correct.
The state concerned,
Yes.
you read the other
Lord, this was,
just please. Other backward class in other categories and rule 9
yes,
and notify the vacancies in at least 2 leading newspapers having adequate circulation in the state as well as in the concerned district, inviting application from candidate possessing a prescribed training qualification from the district concerned and who have passed teachers eligibility test conducted by the government of Uttar Pradesh.
yes,
So the test must be, TET must be from the UP.
yes.
Yes.
Now, now, Lord, this is how,
Would you argue one by one or would you like to argue simultaneously? We will hear then, no problem.
now, Lord, this was also accompanied by the guidelines. And also, they were also advertised. And if I can read that guideline, it's not part of this paper book, but in the counter affidavit of the state in SLP 28154, Archana Rai versus State of Uttar. That guideline made it more clear that you have to be, and Lord, Lord, may I just read it because that would make it clear. And Lord, it says application process. Interested eligible candidate shall have to apply online on the website indicated in the advertisement so and so with relevant information. For this purpose, candidates who have qualified 2-yearly BTC training conducted by the State Council of Educational Research and Training, 2-year Urdu proficiency training, special BTC training will be entitled to apply in their respective district into bracket where they have been selected, and candidates possessing the qualification of DED, 4-year, etc. will be able to apply for any one first preference district. Then Lord, this is another bone of contention, this sentence. Similarly, district. Yeah, please. I'm grateful to my friend.
I can pass on one soft if you're not just.
I'm very grateful to my friend. Lord, page 3 for us.
We can read simultaneously. Yes.
But it says application process. This
Yes.
is also subject matter of challenge in the second batch. And that's why it's important, Lord, both the interested eligible candidate shall have to apply online on the website indicated in the advertisement, along with the relevant information. For this purpose, candidates who have qualified 2-yearly BTC training conducted by State Council of Educational Research and Training, 2-year Urdu proficiency BTC training, special BTC training, will be entitled to apply in their respective district into bracket where they have been selected, and candidates possessing the qualification of DED, etc. will be able to apply for any one first preference district. Similarly, district where there has not been any post advertised, training holder of such district will be entitled to submit application for any other district as their first preference district. Now, Lord, in the first round, which is the judgment of 2018, if your Lordship comes back to the paper book, if your Lordship comes only to one paragraph just to give the flavor of what has persuaded the High Court to uphold the application district-wise. Paragraph 62 for a minute, Lord. It's a small paragraph of 4 sentences. Page 54. Being a big state like UP, several local dialects are in use in different zones. And the areas of the state, there are some important dialects which are spoken in the
Where
state
you are
of,
reading?
not page 54, para 62. In the SLP paper book which I,
Read.
yes. Being a big state like Uttar Pradesh, my Lord Justice Karol got. Being a big state like Uttar Pradesh, several local dialects are in use in different zones and the areas of state. There are some important dialects which are spoken in the state of UP in different zones, districts or local areas like Avdi, Bridge, Bundeli, Bageli, Kannauji, etc. And on this basis, Lord, this kind of this rule was held to be valid. And Lord, the writ petition challenging this district-wise, this was not the first round of litigation, and this judgment is of 2020, by which time, Lord, about 5,000 and odd appointments had taken place on the basis of the district merit. Now, Lord, at the same time, there were some petitioners, because there are 23 districts which were zero district, in the sense that there were no vacancies in those districts where the candidates who qualified in that district could have applied. Now, as per the guidelines, they are eligible to apply in any other district of their choice. Now, that was sought to be resisted and a writ petition was filed, and the learned single judge allowed it, saying that the rule says that the only district, therefore the guideline can't exist. Now, the division bench has reversed in the second batch of the matters before your lordship. And pursuant to that, the state has made the appointment of, so the state has taken the state-wise merit. Each candidate is given a preference of to choose a district of their choice where they apply, and the state is said to have made, as per their affidavit, appointments to about 11,804 candidates. So, Lord, that is now under challenge. That division bench judgment is also under challenge. Now, Lord, as far as the first matter is concerned, your lordship's judgment, Lord, recent judgment in Satyajit, Lord, this is 2000. No, this scale. Lord, I'll just give the citations. Lord, it is 2022 11 scale, page 640. Satyajit Kumar versus State of Jharkhand. Now, Lord, this was a case of 100% reservation for the candidates from the district. And relying upon the Constitution Bench judgment, Lord, in Chorobulu, and Lord, your lordships have taken the view that you can't have a district-wise reservation for teachers or Lord the clerks or any employment, because this is now this is the first point, Lord, and it is my submission that, Lord, we are covered by that. At the same time, Lord, in the same judgment, the appointments which were made were saved for, and the judgment was made prospectively applicable. Now, this is the another aspect of the matter. And now, Lord, the second round about the second part of the zero district, that, Lord, follows the correct law, because the merit is on the basis of the state state merit, and it is only the preference which the candidate makes to go to a particular district, and he gets that point. Now, Lord, that's why, Lord, the state is now is making an application that should be vacated. Now, Lord, as far as we are concerned, Lord, now we are in a also a dilemma, Lord, because the candidates, there are candidates who benefit by reversal of the first round of the judgment, and there are candidates who are benefited by reversal of the second round of the judgment. And this rule, Lord, has been amended from 2018 onwards. So this is only because after this 2018, the state is following the state-wise merit.
It is the right approach.
That's the right approach. That's why I'm not, this is one is to decide only at the interim stage and not permit of the appointments. The
That is the right approach.
yes. So Lord, that's the, so now kindly see Lord this judgment for a minute because
Yes, it is 2022 SCC online.
SCC online.
954.
2022 SCC online.
954. Shall I just?
Yeah.
So as per you, the point is,
Lord, the first point is about the validity of this district-wise
you say this district-wise
is not permissible.
is not permissible.
And that is the, Lord, there are judgments after judgments. And the last one is that, and I'll just read a couple of paragraphs here. Still.
What is your status? What is the petitioner's status?
Lord, the petitioners
He
here,
applied.
yes. Lord,
He applied.
yes, they all applied, Lord. They say that we would be in merit if the merit is state-wise. But Lord, the district-wise merit varies from district to district. So people who are otherwise in higher in merit, in the state-wise merit, do not get appointment, whereas people in a particular district with lower merit are getting them. So that is, Lord, the one part of it. And therefore, Lord, if Lord, we are right on that, then Lord, the second judgment has to be correct because that follows the state-wise merit. But it follows for a different reason, namely the last part of that guideline which I read, which says that, so these are the persons.
But in the previous round that this rule was upheld.
Lord, yes, everything was upheld. In fact, Lord, this is one of the reasons which prevailed with the division bench, that in previous round, you challenge both the advertisement and this particular condition also. And it is upheld, therefore, the division bench also upheld. The subsequent division bench also upheld.
So this is a judgment of Justice Mathur and the CD Singh.
Yes. Now, Lord, if your Lord, if your Lordship sees in the
120 is under challenge.
yes, that is under challenge. Now, if your Lordship sees in the beginning of this judgment at page 4.
What was under challenge before?
Yes, Lord, that's what I want to show. Page 4, kindly see that.
Yes.
In the instant bunch of writ petitions, all petitioners have assailed validity of Rule 14(1)A of the UP Basic Education Teacher Service Rules, which provides the appointing authority to invite application from candidates possessing prescribed training qualification from the district concerned. And the second is petitioners inter alia have also challenged condition 6 as contained in the guidelines issued by secretary so and so, to the extent that candidates doing BTC shall be allowed to apply in the district of their training alone in the first instance. They have also prayed that they may be permitted to appear in the counseling of the other district of their choice, removing district preference. So, Lord, this is that same condition, which is also challenged, but for a different reason, because it permitted only, clarified that only the district candidates can apply.
Can you read this rule 14(1)A?
Yes, page 45.
Page
45.
40.
45. Well, that's the one which I read. Determination of vacancies and preparation of lists. In respect of appointment by direct recruitment to the post of mistress of nursery schools and assistant masters, etc., the appointing authority shall determine the number of vacancies as also the number of vacancies to be reserved for candidates belonging to scheduled caste, scheduled tribe, other backward classes and other categories under Rule 9 and notify the vacancies in at least 2 leading newspapers having adequate circulation in the state as well as in the concerned district, inviting applications from candidates possessing prescribed training qualification from district concerned. The qualification from district concerned, as elaborated in that guideline, confines the applicant to the district concerned. Now, Lord, this is this is amended, which your lordship would find in 2018 itself in para 58. On page 48 bottom,
This rule is amended.
And this offending part is taken up. That your lordship would find at page 49. In respect of, now this present rule reads like this. In respect of appointment by direct recruitment to the post of mistress, etc., the appointing authority shall determine the number of vacancies as also number of vacancies to be reserved for candidates belonging to scheduled castes, backward, etc., and in at least 2 newspapers having adequate circulation in the state as well as in the concerned district, inviting applications from candidates possessing prescribed training qualification and teachers' eligibility conducted by government or by Government of India and past assistant teacher conducted by government. So,
The advertisement is prior.
this is prior. This is prior. These are all 2016 appointments. So 2018 onward.
This amendment have been brought on which date?
18. 2018. 8 February 2000. Court. Only the matter is, so therefore, Lord, that was followed because even before the High Court, when the matter was pending, the appointments were already made.
By about 500 people have been appointed. As per you,
5,000 and all.
5,000 and all have been appointed.
As per the
As per
district
the
merit.
As per the qualification which they received from the district wise
Yes.
and their respective merit in the district.
Well,
Respective merit in the district. Is it so?
I do, yes. Correct.
With their respective merits in the district.
Yes.
Yes.
And now, Lord, the second batch, where, Lord, the candidates from the zero district, because there are 23 zero districts. 24, I stand corrected. 24 zero district.
Where the posts are not there.
Where the posts are not there. Now, the candidates who have done the training in those districts can apply to any one district of their choice. So, Lord, that was the subject matter in the second batch, because that was challenged in the writ petition, and the learned single judge took a view that you cannot permit this, it has to be confined to the district. The division bench reversed it, which is not at the moment under stay, but before your lordship stay, Lord, the appointment letters have been issued to those persons who are from the zero district, but otherwise eligible or coming in the merit as per the state merit.
Overall eligibility is not an issue here.
In the overall merit of the state.
That is only 2 issues. The merit list to be prepared district wise
Yes.
or as per state merit. This is one issue.
That is one issue.
Earlier rule says something district wise, subsequent rule doesn't say anything. So this is one. Another part which you want to convey is that the persons who have passed the BTC courses from their respective districts can apply within their district. This is also do not find place in the subsequent rules. So that is the situation. But because of the advertisement is previous, so the rule which were in existence at the 11th point of time would be applicable. And accordingly, that is the situation.
So we are challenging the validity of that rule even for that year, because your lordship's mandate is very clear that you can't have a district wise, because Lord, then it's everything fragments. The employment opportunities can't be fragmented like this. And this whole argument about the local dialect, particularly for teaching, etc., were negatived in the Constitution bench judgment, earlier judgments, etc. Because Lord, this within UP, Lord, that somebody knows Avdi, so he can't teach in a Bhojpuri speaking area. Now, Lord, India is now too much intermingled to and that's why Lord, state has rightly amended the rules, and they are not. So it's for 1 year, whether it should prevail or not, or whether the equity should prevail. That's the issue number one. The second is, Lord, if we are right on the first, then Lord, the second writ petition, the second batch, which my friend is defending, Lord, I would also be joining him in the argument, because it has to be, I have to be consistent, because
Is the stand of Patwaria?
I don't know. I don't know.
Mr. Hari's there.
Mr. Patwala, you are referring those who are the district representatives, those candidates who are in the district representatives. So we are opposing the state-wise list. Because of the local dialects is very important, Lord, and the 29F is the RTF itself, the mother tongue is required.
In fact, if I may interrupt here, there are several petitions which are pending in Allahabad High Court also. And I am appearing for one of the interveners whose petitions are pending in the Allahabad High Court. And Manoj, those matters are yet not decided, but we are from the same recruitment. I filed an intervention application which is allowed here. Manoj, we are challenging this district wise. I'll give my example, Manoj. I have secured 75 in the merit list, but there are so many districts where the merit list, where the people who have got selected have got secured only 60 or 61 marks, whereas I am 75 and in my district the merit went high. And I was not selected, because if there is a state-wise district list, I will be in. So Manoj, I am challenging this rule on that ground that it can't be a district-wise selection.
Look, there was something I wanted to clarify. If Lordship would just once again have the rule, it does not even say district-wise. What it says is that whoever has done the teacher's training from a particular district, he can apply in that district. Now, that is neither district-wise nor state-wise, I do not know. For instance, supposing I'm a candidate who is born and bred in one district. I do not do my training here, I do it outside, in a neighboring district. Now, I cannot apply here because I am from the neighboring district. The rule, had it said that from the district, the candidate has to be from the district concerned, the matter would have been different. Then they would have had to define what does that mean? Does it mean residence, birth, or the parents staying? Then if it is residence, then how many years of residence?
Can you clarify us which of the petitions are of which batch are of which nature, in which rules are under children?
Yes.
Out of
The
these
first
cases-
case, the leading case, Umesh Chandra is
No,
where,
leading aside leading. Divide
Yes.
those cases.
but I do not know about the others, but my case is with regard to this only, that.
At
you
least
can't-
that must be clear now to us.
Yes, yes.
Also,
Yeah.
otherwise arguing your own cases and going.
Yes, Lord, 14 and 14.1. We
Yes.
can speak for, my friend is appearing in 14, and Lord, I am in 14.1.
So these 14 and 14.1,
Challenge the validity of Rule 14.1A.
for challenging the validity
Yes.
of that rule.
14.1.
And the district-wise merit, Lord, we are challenging the district-wise merit.
Validity and the judgment of the High Court that which confers that he has sit intra-virus.
Yes,
There is no virus.
yes.
Or like it is intra-virus. So this is one. Then remaining cases are those In which
3.2, those we have challenged the district preference. Only we have challenged the circulars.
But what happened was then a circular was issued by the state government because lots of people went and complained that in various districts, like about 24 districts, there were no vacancy districts. And the candidates over there who have the eligibility and the qualification as prescribed by law and including TET certificates, they could not appear because they have not done their training from that district. So therefore they couldn't appear. So therefore they went and raised an objection with the government. Government came out with a circular, guideline stating that all these persons who come from this vacancy district,
they may apply.
they may apply, but first they have to choose one district. And they will only confine themselves to that district. So that circular was challenged by the other side, perhaps that's.
Problem is, Lord, that the 50% of recruitment by the way of the rules and 50% recruitment by way of the circular. In one recruitment, how it is possible in the two rules to be applicable? One is the rules and one is the circular.
That we would
Therefore,
show.
challenge the circular laws because they are taking the two benefits. Zero district candidates, the rules.
Can we ask something like from the government council? Things are not being clear to us.
So Lord, if I can just say one thing, that the people who are supporting the rule, they say that keep it in its purest form. Don't allow, if somebody is in a zero district, bad luck for him, he cannot apply anywhere. That's their argument.
The rule is providing some benefits.
Lord, may I make a submission, one line submission? Your lordships have asked
We are not closing anything.
just
clarity for-
just by words 30 seconds, my lord, and thereafter my learned friend can start. Your lordships have asked the question, the category of patch matters. One category 14.1 and 14, my lord, supporting the challenging the rule 14. The another, my lords, 14.2 and 3, my lords, we are challenging the executive instructions solely on the ground, my lords, and which your lords. That is the question.
That's the same.
Yes. And one set of the fact is Violations of Rule 14 was under challenge,
Unamended rule.
unamended. When the violations was challenged, High Court said this intra-virus. Alright, so this is one part which is under challenge.
Please.
Now, in 2016, when this advertisement was issued,
Yes.
what you sought for? You sought the persons as per unamended rules,
No, my lords, as per the guidelines.
Guidelines.
as per the guidelines.
Yes, my lords.
Without-
The advertisement specifically uses the language of the guidelines. Because the rule does not contemplate a position if there are zero districts. The rule mandates district wise, but my lords, UP has 75 districts, 51 had vacancies, 24 did not have vacancies. So because rules did not contemplate a situation where a district would be a zero district and there would be no vacancy at all, to cater to that situation, the guidelines were issued, and as per the guidelines, the advertisements were issued.
Even 2016.
Yes, my lord. Subsequently, rule has been amended. This is only for this particular year, my lord.
16/12/2016 is the date of that.
And then 18, they themselves.
But the advertisement has this condition of the guidelines.
Yes.
So everyone who participated knew that it will be district wise, but wherever there are zero vacancies, first options will be given to the district people. But my lords, after that, zero vacancy people will have an opportunity of giving one option. It's not like all options are open to them. The guidelines only option that they give that they can.
Please show us that guideline. Where
Yes.
is
But that on which I,
My
the
lords,
tongue
may
corrected.
I have-
That's,
my lords, may kindly have.
yes, that's all. The last part of it, the last part of it,
Your rules, Ms. Bhatti, provided for district wise,
yes.
Please, my lords.
to which the challenge was there,
Please, my lords.
which has been held to be ultra-virus or intra-virus?
Intra-virus.
Intra-virus.
Yes, my lords.
Subject matter of challenge before us.
In the first two SLP,
One minute.
appeals. Yes, my lords.
So therefore, Mr. Sisodia's submission is that in view of this judgment rendered by Justice Shah,
Please, my lords.
then just Madam Nagratna has to be considered.
Please, my lords.
That's what his first submission.
Please, my lords.
Correct.
your second submission is, I mean, the second issue rather, it is that the rules and the advertisement provided for this compartmentalization, so to say, district-wise, if someone is not, if there's no vacancy in a district, then he has to give a preference of another adjoining, whichever district it is. That is,
Please, ma'am.
which,
Rule did not contemplate.
Rule-
Guidelines come from
Guidelines-
contemplate and advertisement did.
no, not guideline, but the circular.
Yes, my lord.
Well, you may call it guideline.
But
It
my-
was
my-
part of advertising.
Advertisement. Advertisement has also, no, first the guideline.
Yes, first
and
guideline.
Secondly, is circular.
I bowed.
Sorry, the advertisement.
My lords is absolutely.
Lord, that sentence, if I can just
Yes,
repeat that.
we-
That similarly, districts where there has not been any post advertised, training holders of such district will be entitled to submit application for any other district as their first preference district.
That's
No
one
legislative
additional-
vacuum, my lords.
One additional preliminary
Rule
point for
6
this.
is there, which is taking care of the 0 district vacancy. So to submission to that effect, my lords, there is a legislative vacuum is not correct with you.
No, but suppose if we come to agree with Mr. Sisodia that in view of this DB judgment,
Please, my lords.
the rule itself is ultra virus, then
Then your lordships is that, but.
what will happen?
My learned friend has said, my lords.
Then what will
this is the
happen?
rule.
Where are you placed
Let me
then?
answer that.
Where are you placed? We want to know first.
So that's my lords. If that is your lordships cautious that my lords rule 14, then my lords we are also out. I am
You
conscious.
know that. That's what we wanted to know.
My learned friend has
Then
said,
the
my
guidelines
lords.
can be saved, no?
Yes,
Sorry?
Then the guidelines can be saved, no?
How?
yes. The effort is to save the guideline.
Cannot be.
Guideline will come.
Cannot be. Para 24 to 28 is very clear by Justice Shah.
Agreed.
Just see, it is not such a simple matter.
Right, right.
No, it is legally it is very simple. But it is complex because of the realities of your being inside. Now, Ms. Bhatti, you tell us,
Please, ma'am.
before we ask you, what do you want to say, Mr.?
There is one preliminary point I made earlier,
What is that?
namely that out of the 19 appeals which were before the Honorable Division Bench, the challenge is in only one appeal.
How does it make any
It
difference?
makes this difference that your lordships have said that quay those whose appointment is not, whose decision is not challenged, res judicata applies. I have 3 judgments exactly on that. That's one point.
But
So that is clearly on point. Number one. Number two, please keep in mind, Milits, that here the guidelines circular, whatever you want to call it, is of 2016. They are well aware of it. The challenge is made after they are not successful. Your lordships have again said on this, well settled, if you participate in a process and finally you are unsuccessful, you can't turn around and challenge it. Now, Milits, post 2018, there is.
We are looking at.
Milits, post.
1 minute now, please.
Yes.
Sir. Just while we are examining it, thinking aloud.
Fine.
Not to be misunderstood. For having expressed an opinion. How best can we make everyone, each one of you happy?
Lordship, may I just respond?
One by one.
I'll,
Starting from Ms. Bhatti.
very well. First the
You are
state,
UP, na?
Yes.
first the state, yes. First the state.
My lords,
Okay.
my lords, the maximum people can be accommodated in this manner, my lords, if your lordships dismiss all appeals. Then, my lords, because the first set of appeals are already, they are high on merit, so they are accommodated in this, by virtue of, my lords, application of the guideline. Where, my lords, for 24 zero districts, people have been given the option.
Sure. What is the total post vacant at present?
Well,
And what may be the aspirants as per the merits?
So, my lords,
What may be the persons who could not got selected or are going to be affected, like Gupta?
Milits, our clients have been given appointment letters. Even after adjusting all of us, appointing all of us, Their vacancies are more than the petitioners.
Now, therefore, interseasonality is the only issue.
No,
Well, look, they've been working.
no, they have not been.
1 minute then, 1 minute, we are
Yes, ma'am.
one by one.
Yes, Manoj.
What fell from my lord is this,
Please, Manoj.
that is there anyone who has been left out in the race regardless of having not approached the court?
But there are people in court and outside court, so
No. Therefore, let us be very clear.
state and only takes this.
People who are inside court, we can understand, but people who are outside court, what would be the status opposition there? Are
Manoj,
there any who are outside the court?
Manoj, outside the court, I have to get instructions, but inside the court, it's only the,
Very well. So
Manoj-
inside, one by one, madam. Yes, you want to say something?
Yes, Manoj, because Manoj may also consider the fact that there are several petitions pending in Allahabad High
That
Court.
doesn't matter, man. We are accounting for everyone.
Yes, Manoj.
You are one of those who are inside the,
Inside the.
you are
court.
inside the court.
Yes, Manoj.
Then you are now, all those who are inside the court, whether before this court or other court, means judicial court, we understand that we take it for granted that you are all inside the system.
Fair enough.
There's no dispute about that. Okay. Another thing which we want to know is, are you fighting for interseasonality?
No. Lord, may I just,
झगड़ा उनका होगा जो बाहर रहेंगे.
please, Manoj.
With clarity,
Please, Manoj.
how many total vacancies?
Gotcha.
Number 1. 2. How many got selected and appointed and working? Number 3. How many persons are there who are within the select list, challenge the rule? Within the select list, challenge the rules. Alright, how many those? How many those who want to otherwise derive the benefits? Alright, and suppose by this time, can you accommodate them? Because from the next time, the rule is completely
That's
changed.
right.
And the rule is as per the guideline, whatever it is. So that would not affect anyone.
Better than the guide. It is now in compliance with the judgment of your lordship, Manoj. It's one state, one
So one state, one
merit.
process of selection and one merit. One
Please,
state, one merit, you
Please,
can
Manoj.
say.
Please.
So that will go. Can you seek instruction to that
Yes,
effect?
ma'am.
Lord, there's already
Kindly take my eye.
figures are, yeah.
Kindly take my IE, my lords. Apart from one figure, everything else is here. We filed an application for vacation of stay. Your lordships will have 61733. 61733 in Archana Rai, SLP 21854. Just give a copy. Oh, you have copies. One more, wait.
Because in the state of UP, vacancies would be there.
Yes, my lordship. Ye bhi lena, please. I'm sorry, one is a paper book, one is a copy.
Application for clarification.
Yes, my lords. Kindly have para 3 of this, my lords.
Yeah, done. Para 3.
Yes, my lords.
Pursuant to the counseling conditions.
Yes, my lords. In accordance with the above, appointment letters were issued on 30th December and 7th January to several eligible and meritorious candidates by various district basic education officers. As many as 1796 appointment letters were issued on 30th December and another 4060 appointment letters issued on 7th January.
So the Mr. Nilesh Gupta's clients within this.
Yes, my lords.
Hmm.
Then, my lords, 5948 were given in 2018 itself. These were district wise, man. By
Like
5948 in 2018,
it dated 11,000.
total of 11,840 appointments have been made in total notified vacancies of 12,460. But my lords, the first line candidates, they were given appointment orders, but they've not been given joining.
So you are concerned with these persons who have not been given joining.
Yes, my lords. But they are on merit, my lords. In fact, higher on merit.
Now we are asking about those candidates who are assailing
Yes, my lords.
and inside the court.
Yes.
Like who are assailing this. How many those are?
Roughly around 600. Roughly around 600.
Including Allahabad High Court. Who are inside.
We don't know.
Because we are the two.
Are the 600 are the petitioners before?
Yes,
Before this.
Before this.
Madam, how many in your,
My lords, I know that there are at least 100 in one of the petitions. I don't know, there are some 8 or 9 petitions there. I don't know the exact number.
No,
I'll
let-
try to find.
let-
State can always.
Can Aishwarya ji, you
Yes, my lords, I will.
ask about that.
Please, my lords.
Those candidates may be there,
Yes, my lords.
but
Please, my lords.
whether they may fall within the purview of the above than cutoff. We are concerned with those
I'm
persons.
not on, my lord.
Person who are inside the court
Yes, my lord.
secured above than cutoff.
Yes, my lord.
Then comparing to the vacancies available 11,804, 12,460. Approximately these vacancies comes to
650.
600,
Yes, my lord. Or 650.
654.
whatever it is.
Yes, my lord.
So you want to know this figure.
Please, my lord.
Suppose this matches
Yes,
and
ma'am.
everything goes away,
Please, my lord.
you can accommodate and finish it.
Yes, my lord.
The other person who have not come, who are fence sitters,
Yes, my lord.
no question of extending any benefit.
Please, my lord.
And even otherwise,
This data who's here is easy, my lord. Allahabad High Court we will have.
you take it,
Yes,
you
ma'am.
take it next week. We have
Good.
required by this time.
Yes,
We'll take it in the next week.
May I,
Just to show you. Yeah, we want that if some
I want to
solution,
just, yes,
the brother has pointed out, express something.
I
we
follow
shouldn't
that.
expect that, and
Good.
we can ask.
Apropos that only, I just want to share one suggestion. I'm not now, we are not on the merits. Lord, one scenario is that everything is unscrambled and the rule is declared invalid and all the appointments go. Now, Lord, this can be a very cynical view or this can be a practical view depending on how you look at it. Even in the judgment which I cited, Lord, because I had the privilege to assist that
Save.
court,
Save.
the saving was done and it was done prospectively. And there have been subsequent proceedings by which, because the,
Subsequently, if we will go prospectively now, then Mr. Gupta's persons will be affected. So the appointment orders have been issued, joining have not been permitted.
no, therefore, no,
No, my
I'm
lord,
saying,
they are high on merit.
We are high on merit
These
also, Malak.
petitioners will.
We are the most,
their
it's
clients
most
will-
ironical with us. We are covered by a lordship judgment. We are high on merit. We have appointment orders, but we are out.
but there are, Lord, I'm making this submission because there are
This
They are-
because of zero
they are
district.
Zero district
Lord,
candidates.
there are
Because of the
people
zero district.
who would come in the merit, in the district and also in the state-wise merit. And there are a lot of people where they are converging on
A
the,
lot of people, we are not interested.
no,
Everyone.
but that's why,
We are interested only to those who are in the court.
yes, Lord, that's why
How
I'm,
we can resolve it.
that's why, only for that resolution, I'm making the submission. Because, Lord, these are the submissions where somebody can be called a very cynic and somebody can be called very practical. Lord, this is how, Lord.
We are interested
Yes.
in practical solutions.
Yes, now, Lord, that's why, apropos that, Lord, even in that matter, ultimately, Lord, the appointments which were made were saved, plus the more vacancies which were there with the state, they were given to people who would have come otherwise on the state.
no,
matter.
Mr. Sudhakar.
Now, Lord, I'm sorry.
No.
Let me just complete it. I follow, Lord. I'm not saying that Lordship would expand the.
Then what is the point you wish to make?
I'm just completing.
Aishwarya ji,
Yes.
I'm just
Get
completing. it.
instructions, ma'am.
you discuss with your officers.
Yes, ma'am.
Because, Lord, if all
Just
the,
wait, just Mrs. Sisodia, we want some solution, otherwise we are hearing.
only for that, I
We will
wanted to say
decide.
after your Lordship
We
finishes.
have understand this, we will decide to find out some solution.
Yes, madam.
Privately, and what may be a solution that may be practicable
Yes,
to
madam.
everyone.
Please,
You
Malad.
find out some solution, we are leaving on you.
I bow down, Malad.
All right, we are appointing you as a mediator in this matter. Take it this way.
We are in safe hands.
All right. You.
Choice of a mediator is very good.
We are in safe hands.
So we want that you sit,
Yes.
find out a way
Please, Malad.
and propose on the next day.
Lordship's please.
All right, we are taking the next witness.
I'm very grateful.
All right, and we'll finish it.
I'm very grateful.
You have understand the controversy now.
Lordship.
By this time, initially I was thinking,
Lord, even if it is,
So far as
Lord, even if it is a
language-
regular miscellaneous day, let it be
even
taken up.
we will hear on that.
Yes.
We will hear. You can, our bench, we have no problem.
Lordship.
In our bench, we have no problem. We can hear, we can sit up to 4 o'clock.
No, no,
Even
Lord,
you
what
want,
I'm
we can
saying
get
is, even if it is a not a regular day,
Is a-
let this matter come up.
It is a regular event.
By this time,
secretary has said-
if it is not coming, you're fixing.
Yes.
All right, you point out, we list.
We'll come and mention on Wednesday morning, Malad, with the proposal will come on in the morning itself.
We'll-
That's all I'm.
Very great.
But
I think that may be a right approach and everybody would be happy by
Lord,
it.
that's,
so only for the purposes of clarity. please.
Yes, Malad.
Such of those who stand appointed, to whom letters of appointments already stands issued, who are serving the state, they would be protected, number one. The rules, we shall put a quietus to whatever it is, because in view of the subsequent amendment, we need not go into the legality of the judgment rendered by the court. 3, there is no there shall be no, your statement would be recorded, dispute of inter-se seniority,
Yes, Malad.
as it is, where it is, whether you're in the district or whether you are in the state or district of your choice or other district, all issues are.
Yeah.
Of inter-CC.
yes, Lord.
Or a word
Lord,
from-
first the job, not, why seniority? Lord, we don't want to talk of it.
That'd be a separate round.
Otherwise, it's a,
Yes, Malad.
without having a challenge before